The so-called free speech bastion of Florida has once again been caught violating the free speech rights of one of their citizens. Because, of course, a federal judge on Tuesday temporarily blocked a law in Florida that barred a transgender teacher from using her preferred pronouns. Chief U.S. District Judge Mark Walker had granted in his decision transgender teacher Katie Wood a temporary injunction against what is known as the Don't Say Gay law, writing that the law violates her First Amendment rights. I love this scathing opinion. Walker wrote, "Once again, the state of Florida has a First Amendment problem. Of late, it has happened so frequently, some might say you could set your clock by it." Well, to be fair, in Florida, a lot of Republican-controlled states as of late, you really do have to set your clock back to like the 1800s, all right? Now, this time, he writes, the state of Florida declares that it has the absolute authority to redefine your identity if you choose to teach in a public school, which, by the way, that's government. So the question before the court is whether the First Amendment permits the state to dictate without limitation how public school teachers refer to themselves when communicating to students. The answer is a thunderous no. I love this. So this is not only is Walker just absolutely walking all over DeSantis and this ridiculous law, but he's pointing out that this is not protected. This is not something that the Constitution allows you to do. The Constitution protects free speech. It doesn't allow the state to come in and crush it. And that's exactly what Ron DeSantis was doing with this Don't Say Gay law. Now, this whole thing started after he had signed it, which, again, bars teachers from using pronouns or titles that don't align with their how they were born, right? Now, Wood and two other teachers, one who's a trans woman, one who's non-binary, they filed a lawsuit in December in the U.S. District Court for the Northern District of Florida. Now, Wood, who has taught math at Leonard High School in Hillsborough County since 2021-2022 school year, said that in the lawsuit that her district was supportive of her identity and that her students had known her by Mrs. Wood. But under the new law and its subsequent expansion, she was prohibited from asking students to call her Ms. Wood and wasn't allowed to correct them if they misgendered her or called her Mr. or by he and him pronouns. So she ended up having to ask students to call her Teacher Wood. Teacher Wood. To which she said made her feel stigmatized because no one else at the school had to go by that title, okay? They were allowed to use pronouns. So now the three plaintiffs had argued that Florida's law discriminates against them on the basis of sex and violates Title VII of the Civil Rights Act of 1964, Equal Protection Clause of the 14th Amendment, and Title IX of the Education Amendments of 1972. They also argued that it violated her First Amendment free speech rights, and two of them had asked the court for a preliminary injunction to block the enforcement of the law while their case is ongoing. Walker had granted it because he said her free speech rights were being violated and that violation was ongoing. So now one of the other teachers, since they were no longer working in that field, couldn't do the injunction on their behalf because this violation was not ongoing. So that's what this is about. Her free speech rights were currently being violated, and so therefore we got to put a stop to it while we litigate the rest of this. Now, Wood said in a statement on Wednesday, "I'm hopeful that this ruling will encourage those who feel powerless to stand up for themselves. Where there is pain, there is power, and anything can happen when good people stand up together." Well, I love that message, and I love what she's doing and standing up for people, not just in Florida, but in everywhere else where Republicans think that they can use the government to destroy pronouns. Again, imagine being angry at pronouns. I don't understand, since they all use pronouns themselves. Now, Walker happens to be an Obama appointee. I'm not surprised. But he quoted Walt Whitman's Song of Myself in his opinion, and I want to share this with you. Quote, in sharing her preferred title and pronouns, Ms. Wood celebrates herself and sings herself, not in a disruptive or coercive way, but in a way that subtly vindicates her identity, her dignity, and her humanity. Now that's important because Republicans say, "Oh, you're shoving this down our throats." Wait. Asking you to just use a particular pronoun, her, or in this case, but he or him in other cases, or they, that's not shoving it down anybody's throats. All trans people are asking for is respect the name and respect my pronoun. That's it. It is all about just the basic level of respect here. Basic dignity, basic identity, basic humanity. Now, the section of Florida's law, getting back to Mr. Walker's decision, said that prohibits her from using the pronouns of her gender identity, has silenced her, and by silencing her, forced her to inhabit an identity that is not her own. The state of Florida has not justified this grave restraint, and so the United States Constitution does not tolerate it. Ours is a union of individuals celebrating ourselves and singing ourselves and being ourselves without apology. And that's it. And unfortunately, the state of Florida, if you're a trans person, does not want you to be yourself. Not because it harms anyone else. It doesn't harm children. It doesn't harm anybody. It might harm the feelings of a few transphobes, but that's it. It doesn't actually do any material harm to anybody to use a pronoun, okay, or to accept someone as being transgender or someone as being non-binary or anything like that. So I love this decision. Walker is base as hell. No, look, if you're somebody who doesn't like trans people, I think you're a bigot. I think you're transphobic. That's my opinion. All right. Now, that said, are you allowed to have those opinions? Yes. You're allowed to have those opinions and not be punished by the government for having them. That is what free speech is about. You're allowed to have those opinions. You're allowed to, even to be vocal about those opinions. What you're not allowed to do is to be vocal about those opinions and not expect people to push back using their own free speech, right? But that's, again, free speech. It does not allow, however, that free speech does not allow you to use the power of the state to enforce that bigotry on someone else. That's what's going on here. By not allowing Ms. Wood to express her identity and use her preferred pronouns at her job, which is to work for the state, to work for the government, Florida has used their state power to silence her, to enforce their opinion, the opinion of Ron DeSantis, on another person. You can't do that. Ron DeSantis might believe that she is not a she, but he can't use state power to dictate that. It is a violation of her freedoms, of free speech. It's funny, all these free speech defenders don't seem to understand what free speech actually means. The government cannot punish a person for their speech. Pronouns are speech. Pronouns are identity. And so you can't use the government to silence someone's speech on their identity, on their pronouns. You don't have to agree with it. You don't have to like it. But if you believe in free speech, then Florida or any other states that, do this cannot be allowed to discriminate against trans or non-binary teachers and prevent them from using their pronouns. Okay? Judge Walker, he made the right decision. He made the lawful decision, the constitutional decision, and I hope that injunction is successful and they end up ultimately doing away with this ridiculous and unconstitutional, hateful law.